What we're hoping to do in this session with you all is to recap briefly those 2025 changes that have already come into effect and that you may already know about. Talk about the new requirements that came into effect just a month ago, and then we're going to look at some emerging developments to watch. So these are things that you can just keep an eye out for as 2026 unfolds. There's some significant emerging developments that we'll talk about. And then I'll end with just wrapping up with a few practical risk management tips that take all of this into account. So I just want to first give the disclaimer that everything that I'm going to walk through today is considered general legal information, not legal advice. In order to give legal advice, there's all kinds of law society requirements that I would have to do in terms of conflict checks and in terms of a retainer and things like that. So these are high level, just general legal information that everyone can take away and hopefully put to practical use. Um, and also another disclaimer, this is all Ontario specific. There may be some folks here who, their nonprofits are based in Ontario, but maybe they have staff in other jurisdictions as well. So this webinar is Ontario specific. And as I go along, please feel free to put any questions you might have in the chat. I'll try to stop every now and then in order to take a look at the chat, or I'll just pause and see if there's any questions, and feel free to raise your hand and unmute yourself and ask questions. Um, alors, je vais présenter en anglais aujourd'hui, mais soyez libre de me demander des questions en anglais ou en français si tu veux, s'il y a des francophones ici. Okay, so let's get started here. So now we're entering into the recap I mentioned of amendments that came into force in 2025. So this first one, which came into force July 1st, 2025, this is a amendment under regulation under the Employment Standards Act. And what it does is it requires employers to provide this list of pieces of information to new hires. It should be ideally provided before the first day, but the amendment does say that it can be provided as soon as possible thereafter if for some reason you weren't able to provide it technically before the first day. This requirement, so as you can see, that's pretty standard stuff. The employer's legal name, the employer's contact information, the work location that the employee will be initially working from, their starting wage, what the pay period and pay day is, and what their anticipated hours of work initially are. And so this applies to employers with 25 or more employees in Ontario. However, as I said, these are pretty standard things that generally should probably already be in your employment contracts or offer letters. Even if you're not technically bound by this requirement, it may be a good idea still to take a look at your offer letters and contracts and see whether there's any of this information that's missing. And one thing to note is that this requirement doesn't apply to what the act calls assignment employees, which are employees that you get on a temporary basis from a temp agency. So those are the only categories of workers that are excluded. Okay. And the next quite significant amendment that came into force June 19th, 2025, is a new type of job protected leave under the Employment Standards Act. And so so this leave doesn't, it applies to all employers regardless of size. So this is not one of those where, you've got to have 25 or more employees. This is a minimum standard that applies to all employers with employees who fall under the ESA. So essentially, it's by job protected leave. What we mean by that is the act prohibits any form of reprisal or penalties for somebody taking this leave. So generally, that means you would have to be quite careful, and there'd have to be some very special circumstances. For example, if you were to terminate somebody while they're on this leave, right? So it's what this leave gives employees entitlement to is unpaid 27 weeks of leave within a 52-week period. And employees become eligible for it after having at least 13 weeks of employment, and where they have a quote unquote serious medical condition. And they have to have a certificate from a quote unquote qualified health practitioner. And that certificate needs to explain that, they have a serious medical condition that requires them to be off work. And it needs to explain, the period of time for which they need to be off work. And so interestingly, the act does not define the term serious medical condition. So it seems like they have intentionally left the definition of that to the hands of healthcare practitioners. So essentially, it's up to a healthcare practitioner to assess, and come to their own determination as to whether what the individual has is a serious medical condition. And the act does define who a qualified health practitioner is. So it would include a physician, RN, or a psychologist, for example. And when it comes to the certificate, what's important to note is that, the same principles around the type of medical information that employers are typically entitled to have, those same rules apply. So we know that an employer can't ask for a diagnosis. So you're not entitled to know, exactly what illness the person may have. However, you may be entitled to know information about prognosis or what their functional limitations are. So those same principles would apply here when it comes to the medical note to access this leave. So as I mentioned, it's up to 27 weeks, and that 27 weeks is within a 52-week period. It need not be taken consecutively, all at one time. So, for example, it could be that the person's physician believes that, okay, yep, right now they should be off for 4 weeks. And then later in the year, they provide another, note saying that, the physician would recommend another 8 weeks or whatever it is. So it's a total of 27 weeks of unpaid leave within a 52-week period. And it is also important to note that it's 27 weeks total, regardless of how many different medical conditions one might have. So you wouldn't get, for example, 27 weeks for each serious medical condition that you may have as an employee. And so Just a couple of notes on this. I mean, so some of you may be operating in unionized workplaces, and it's possible or likely that your collective agreements already guarantee, or your sick leave benefits that you provide would already cover something like this. So, what these ESA requirements are is they represent the absolute floor, so the minimum. So, this is saying that, all employees are entitled when they have a serious medical condition to 27 weeks of unpaid leave. So that's at a minimum. But you may work in workplaces where, the person won't have to take that time unpaid because you've got other benefits that you provide your employees and things like that. So this is really the floor. And another important thing to take into account is your human rights obligations here. So we have our ESA, Employment Standards Act obligations, but we also, as employers, have our obligations under the Ontario Human Rights Code. And so, it could be that you've provided 27 weeks of leave, but then your human rights obligations to accommodate may still continue from there because there's no fixed time limit on the requirement to accommodate under the Human Rights Code. And so that's where, depending on the situation or your familiarity with the Human Rights Code obligations, you may need to seek some legal advice around, whether you've met the threshold of undue hardship, or whether there's, some kind of frustration of contract that would allow you to terminate the employee. So that's really tricky terrain, and so that's why I just wanted to flag that this leave entitlement and human rights obligations really intersect. And then finally, the final note here is just that the Act also requires that employers maintain records of uh, all documents relating to this long-term illness leave for at least 3 years after the leave has expired. So just a little note there. And then the final kind of update that came into effect in 2025 is a minimum wage increase in Ontario. So for those that have staff that perhaps are paid on a minimum wage basis, you just want to take this slight increase into account when it comes to budgeting and grant applications and things like that. Okay. Okay, so I'm going to jump into the changes that became effective at the beginning of this year. But before I do, I just want to see whether there's any questions about anything that I've mentioned about the 2025 changes. Um, Sam, you may be able to see the chat better than I can. I'm not sure if there's anything in there or.
No questions quite yet.
Okay, all right. Okay, so. Okay, so we'll hop into the changes that came into effect earlier this year. So most of these changes apply to employers with 25 or more employees. However, I will highlight some practices that I think really make good strategic sense to implement, even if you have less than 25 employees. So I'll flag that where I think that's applicable. Excuse me. And also the the focus of most of these amendments that came into force this year, it's around a policy direction that tries to promote increased transparency, increased fairness, and increased accountability when it comes to the recruitment process. And so you'll see kind of a common thread in that regard. Okay, so the first significant change that's come into effect is relating to compensation transparency. So, some jurisdictions, I know BC had already introduced this a few years ago. I'm not sure about other provinces, but for Ontario, it's now in effect. And what it requires is that where you post a publicly advertised job posting, so this doesn't apply to internal job postings. But where you post a publicly advertised job posting, you now must include the expected compensation or an expected range of compensation for the position. And the range can't exceed $50,000. 50,000. So that means, you couldn't say, oh, well, this position is between 50 and 150,000 in compensation. It's got to be, between 100 and 150. So it's got to be the ranges that you provide in the posting are limited to $50,000. And it applies to wages, not benefits entitlements. So we're talking salary here. And it doesn't apply to compensation over $200,000, or if it's the case that you're putting a range in, if the upper end of the range is above 200,000, then you wouldn't have to include this information in your job posts. And so, again, I just want to reiterate what it doesn't apply to. It doesn't apply to internal job postings. And the regulation also explains it doesn't apply to things like, a broad recruitment campaigns that really don't relate to any specific position. And of course, it also wouldn't apply to roles outside of Ontario. So again, if you are a nonprofit that, has staff in various jurisdictions and hires, staff across the country, you wouldn't have that obligation when it comes to a position in, X other province, for example, assuming that province doesn't have this type of regulation. But I still think, even though, as I mentioned, this applies to employers with 25 or more employees, I still think it's good for smaller organizations to be aware of, because I think as job seekers become more accustomed to seeing this information in job postings, their expectations may shift. And, it's supposed to be a signal to a commitment to fairness and transparency, and an initiative that is supposed to promote pay equity as well. And so, if you are a equity oriented nonprofit, it may be a good practice to consider, implementing this pay transparency in your job postings, even if it's not technically required of you as a smaller nonprofit. Okay, and this is a very welcome development. This also came into force the beginning of this year. So the Employment Standards Act now bans any mention of a requirement for Canadian experience in job postings or on application forms. So, I guess what we can say is, this is a prohibition on the requirement for Canadian experience, but it doesn't prohibit, for example, if the job requires it, requiring knowledge of, for example, certain Canadian regulations or standards. So one can require knowledge, but not actual work experience within Canada. And again, so this applies technically under the ESA only to employers with 25 or more employees. However, even if you're a smaller organization, it's strongly recommended that you review your job postings for anything like this because Canadian-based requirements have always carried human rights code violation risk. And there has been some recent case law on that from the Human Rights Tribunal of Ontario as well. So just a note there that that's always carried a risk, but now the ESA is, also prohibiting it. And again, this is again about new obligations that apply to publicly advertised job postings for employers with 25 or more employees. So again, this one doesn't apply to organizations with less than 25 employees. Um, but this requires that the use of AI when it comes to screening, assessing, or selecting candidates, that be disclosed in your job postings. And so AI is defined under the Act very broadly. So it can include, things like resume screening and resume parsing tools. And I think these days, quite a lot of organization use tools like this, especially if you're an organization that gets, a lot of applicants, regularly. And so this requirement would require you to disclose that you do use AI in the recruitment process. And finally, we have the vacancy statement requirement, which requires employers with 25 or more employees to include in their publicly advertised job postings whether the posting is for an existing vacancy or not. So, is this posting for an actual position that's vacant, or is it an anticipated vacancy, or you're just looking to create a pool? And the impetus here obviously seems to be to save job seekers, time, if they may not be interested in applying if it's just an anticipated vacancy or a pool. So it's just about that transparency once again. And yeah, so something that many employers do anyways. And if you're a smaller employer, it may still be a good practice to implement. Okay, and yes, and there is another requirement here when it comes to publicly advertised job postings, and this relates to the requirement to follow up with interviewed candidates. So, not all candidates, but interviewed candidates within 45 days of their interview, or if they had multiple interviews, then 45 days of the last interview. And what you're following up about, according to the Act, is whether a hiring decision has been made. So it doesn't require that the hiring decision has to actually have been made within that 45 days, but you should at least within that 45 days be updating the candidate about, whether a decision has been made. And again, I mean, not mandatory for smaller employers, but it's a sensible, considerate practice for job seekers, and so one may still choose to implement this practice. Okay, and so this is important. So the Act also, as of this year, introduces some new record retention requirements under the Act. And so, what this requires is that employers need to retain public job postings for at least 3 years after you've taken the posting down. And that includes related application forms. And as well, those that communication I just mentioned with interviewed candidates about the hiring decision, that also needs to be kept for 3 years as well. And so, I have a little note here about privacy obligations because many job applications include personal information regarding candidates and, communication to a candidate telling them that they didn't get a job or whatnot. That may also constitute personal information. And so it's really important when we think about record retention to also make sure that we're thinking about the security of those records and consulting with IT or other folks who may be able to advise us on how to make sure we're retaining all of this personal information as securely as possible. And so again, this doesn't apply to employers with less than 25 employees, but it's always generally been considered a good practice for all employers to maintain records like this for a period of time, and I would say 3 years is quite reasonable because of the possibility of litigation or human rights complaints. You shouldn't be destroying records like this within a minimal time period. You should have a system for retaining them for sure, just in case of litigation. Okay, and this is another one that came into effect the beginning of this year, a requirement to have clean washrooms. This is an amendment under the Occupational Health and Safety Act. And so the language requires that employers maintain clean and sanitary washrooms, and that they post records of the date and time of the two most recent cleanings. And the language talks about how that should be in a space that's clearly visible to employees. And there's also under the Act some other special requirements that apply mainly to the construction industry when it comes to porta potties and things like that. But for our sake here, this is the amendment that's applicable to our nonprofit space. Okay, so just in terms of a recap of, what are the practical action items that come out of the changes that we've just looked at in 2025 and the ones that have come into effect this year. So firstly, first action item would be ensuring that any staff that work on HR related issues, that they're aware of these new requirements. And I'm happy to have Volunteer Ottawa share this presentation, by the way, with all attendees in case you haven't been able to take notes of everything. Um, Secondly, you want to take a look at your offer letters and at your employment contract templates to make sure that they include the mandatory information for new hires. And given the new ESA leave, the long-term illness leave, that may, depending on, the policies and procedures that you have within your organization, That may require updating leave policies or employee handbooks or internal leave systems to reflect this new leave. And then, given all of the new job posting requirements, you'll definitely want to review recruitment policies and job posting templates at your organization to make sure that you're complying in terms of the new requirement for compensation ranges and AI disclosure and vacancy statements, and again, removing those Canadian experience requirements if you have any. And also, as I mentioned, definitely worth it to, in terms of the record keeping requirements that have been introduced this year, definitely worth it to, work with someone that specializes in IT and or your HR staff to find, internal ways and systems of tracking some of the requirements in terms of how long these documents are going to be in our system for, how we'll know that the 3-year mark has been hit and we can now, delete. How are we tracking internally the 45-day period for getting back to candidates? And if you're if you're an organization that is a bigger organization and has a lot of job applicants or a good number of employees, then you may need to discuss storage capacity and things like that with IT as well. And then when it comes to the Occupational Health and Safety Act amendment around clean washrooms, so you're just going to also want to make sure that you're updating your internal policies or procedures on that to ensure there's a record of the last two washroom cleanings and also perhaps coordinating with cleaning staff or contractors so that they can work with you on this as well. Okay, so I'm just going to pause there to see if there are any questions so far.
There's nothing in chat quite yet, but if anyone wants to raise their hand and like take a second to ask a question out loud, you're free to do that. Go ahead.
Hi, Sasha. Thanks so much for those overviews. I just had a general question on the, I guess, disclosure and AI. Is your expectation that that's going to be on the posting itself, or during the actual process as the employee is interviewing that you're telling them, so the next stage will also be done by AI? Where do you anticipate that that's going to be more or less disclosed when that because of that requirement?
Thanks, Amaka, and good to see you. I would say, yeah, so the amendment, the language that the amendment uses is that it suggests that it should be actually on the posting itself, from my interpretation, is what I think. However, that's interesting. I could take a closer look at the wording to see if maybe it isn't as clear as I thought as I had assumed it was. But yeah, I think many are interpreting this as, putting it on the job posting itself. However, if it's a requirement to disclose to jobs. Yeah, no, I would say it's probably a safer bet to include it on the posting itself. But again, I'm happy to take a closer look at that and see whether there's any workarounds. Yeah. Thanks for the question. Any other questions? Okay. All right. So then I will jump into a look at some interesting emerging developments to look out for between now and the end of this year, possibly. So this is another new leave, referred to as the child placement leave. However, it's not yet in force, and it's unclear when exactly it will come into force. We're all kind of just waiting to see. So, right now the act does have language around what this child placement leave will entail. However, it says that it will come into a force on a day to be proclaimed by the lieutenant governor. So it's not yet technically in force, but we can watch out for this. And what it does is it applies to employees who've worked for the organization for at least 13 weeks and who have adopted a child or have had a child through surrogacy. And what it entitles those employees to is to an unpaid leave of absence of up to 16 weeks. It can be split among more than one employee. Um, and it can only be taken within a single period. So, unlike the long-term illness leave that could be broken up into different periods, this one needs to be taken in one consecutive chunk. And so there's no differentiation here between employers with 25 or more employees. It kind of applies across the board, but the same record keeping requirements of 3 years apply to all related documents related to this leave as well. And so again, if you are, especially those in a unionized workplace, but other workplaces as well, you may already have implemented this type of benefits for adoptive parents and for parents who have a child through surrogacy. And that's great because yeah, the intent of this new leave is really to align the rights of adoptive and surrogacy parents more closely with the entitlements that birth parents already have. So this is a really, really great development. And then, so this is very, very interesting. This is certainly a topic that, I attend quite a lot of employment law, CPDs, we call them, continuing professional development programs. And this is always, over the past, I would say, 2 years, been a super hot topic. And employment lawyers are just waiting with bated breath to see how this will all land this year. This is going to be a big year when it comes to what is considered a valid and enforceable termination clause within an employment contract. And this may sound a little bit boring at first, but I'm going to really try to explain why it should matter to you and why, in fact, I think if there's one thing you walk away with today, it needs to be this. So and again, just in terms of those who may be in non in unionized workplaces, this would apply to your excluded staff. Because we know that your unionized staff, their employment contract is considered the collective agreement, but you may have non-unionized staff that are excluded from the bargaining unit. So this would apply to them. And then in a non-unionized workplace, this would essentially apply to all staff that you have employment contracts with. And so over the last 2 years, the the courts in Ontario have basically called into question the validity of language that has been used for a long, long time, for decades, in employment contracts. They've now called some of that language into question, and it's created a big gray area. So the cases all revolve around uh, employment contracts that have the following kind of terms within their termination clause. So contracts that speak to an employer's ability to terminate an employee, quote, at any time, or to terminate for any reason, or to terminate at its sole discretion. So, language like that, we have seen two different lines of case law come out of the Ontario Superior Court, where in some cases, they have struck down termination clauses that include this language, this at any time language, for any reason language, at the employer's sole discretion language. And then in other cases, the same court, different decision makers, but same court, has has struck down or has upheld those clauses. So some cases they're saying, yep, the clause is valid. Other cases they're saying, nope, the clause is not valid. But next month, so this is very timely. As of next month, the Ontario Court of Appeal is going to be hearing at the very same time two of these conflicting cases. So Baker and Lee, they're going to hear them together. And so lawyers in the employment bar are really looking forward to getting clarity from the highest court in Ontario about, like which way should we be advising our clients? Like what is the deal here? Because it's been very confusing over the past 2 years. And so why does this matter? So it matters essentially because depending on what the court's decision is, it could mean that many contracts in employment contracts in Ontario become unenforceable. And why that matters, in terms of practical sense, is that if you have an invalid, unenforceable termination clause in your employment contract, then that is really one of the most significant and costly possible sources of liability for an employer. And here's why. So usually termination clauses in employment contracts, drafted by an employer. Usually, the employer's aim is to minimize what they have to pay an employee as notice upon that employee's termination. So the clause is usually aimed at trying to restrict what we have to pay out to the ESA minimums, so the minimum entitlements under the Employment Standards Act. Essentially, every employer that drafts an employment contract, that's usually what the termination clause is aiming to achieve, to minimize liability and minimize the amount of payment in lieu of notice that you have to provide an employee that's terminated without cause. So the thing is, if your clause in your contract is invalid because, maybe the Ontario Court of Appeal is going to find that actually, yeah, we shouldn't be using this at any time language, or saying that it's at the employer's sole discretion to terminate and that they can terminate for any reason. So if your clause has any of these types of terms in it, then yes, there's a possibility, as the court has found in Dufo and Baker and Chan, that it could be considered invalid. And if it's considered invalid, then that means that it's not the ESA minimums that apply. It is common law reasonable notice that applies, which is usually much higher than ESA minimum standards. And so, what we mean by common law notice is we mean this whole body of court cases where uh, it's judge-made law, where judges have said, okay, here's what we consider to be reasonable notice. We're going to take in factors such as the role of the employee, their length of service, their age, and we're going to come up with a system of assessing, how much money or how much uh, notice or pay in lieu of notice is required to this employee that you've terminated. And that judge-made law is it tends to be much more generous than the Employment Standards Act minimum, which is why employers generally try so hard in their employment contracts to have language that will ensure that they're limited to just having to pay out ESA minimums. But if your contract is not drafted well, then it exposes you to a much higher payout. And so this is why I say, if you walk away with one thing, it's really this, that I strongly recommend that you get your employment contracts reviewed. If your organization hasn't done so in at least within the last 2 years, I would say that that should be a priority for sure. And this isn't just, I know lawyers can tend to be very alarmist, but, I was just talking with a director of a nonprofit in Ontario, a small nonprofit, the other day. And she had a real live example of this, right? Where, she was telling me that a couple of years ago, they unfortunately had to terminate an employee. And they didn't realize that the termination clause in their contract was not enforceable. And it required, they were able to settle with the employee, but the employee had a strong case because the termination clause clearly wasn't enforceable. And so it led to a pretty big payout that was necessary. And we know, given the current climate and context of the nonprofit sector, where so many organizations are surviving on project-based funding, that few will just have $100,000 sitting around to pay out as a settlement, right? And so this is why I really stress that it's important to, if you're going to do one thing regularly, then it probably should be a review of the validity of your employment contracts. Okay, so I just want to, before I go on, see whether there's any questions about anything that I've just mentioned there.
We do have one question in chat from Emily. Will we need to issue new contracts to current employees?
That's a great question, Emily. So you're going to want to seek some advice on that. That's one of the areas that it's a little bit tricky. I mean, you can always today update your template contracts that, from that are going to apply from now going forward. But it is a little bit tricky when we talk about amending the contracts of current and existing employees because it raises the possible risk of constructive, what we call a constructive dismissal. situation where, the employer is seen as having made a unilateral change to the fundamental terms of the employment agreement. And so there could be an argument that the employee makes that, that's considered constructive dismissal. So you're going to want to seek some advice around how to do that, if you should do that, depending on what their employment contract looks like at the moment, and ways that you can possibly do that while mitigating legal risk. For example, providing something to the employee as consideration. So, whether that's a signing bonus or an increase in pay or whatnot, there's different strategies of kind of mitigating the legal risk around that. So, just in short, there's some considerations that definitely need to be taken into account if you're going to amend the employment contracts for existing employees. However, much easier, and I'm not saying it's impossible, just that it's you have to proceed with a lot of caution, and I would suggest getting advice on that. And On the other hand, for employees moving forward, for your templates moving forward, that's kind of a easier, simpler fix. Thank you for that question, Emily. Oh, is there anything else in the chat, Sam? I do see a hand up. I think
No,
Abida.
just the hand.
Okay. Abida, I hope I'm kind of pronouncing your name correctly.
Yeah, it's correct. I just wanted to have a question of like, if there is at any time, any reason at sole discretion, this kind of language is not acceptable, like what is acceptable for a non-for-cause termination?
Yeah. That's a good question. And that's a question that many seasoned employment lawyers have. Because, like I said, it's a kind of this newer development that this language has been called into question. And so I think we're going to be able to have, hopefully, much more clarity this year. Let's see how quickly the Ontario Court of Appeal comes out with their decision after this hearing in March that I mentioned, because the fact that they're deliberately hearing two conflicting cases together suggests that they want to provide, um, they want to provide more guidance on this issue. So. But I know some folks, what they've been trying to do to navigate this gray area is finding ways of, perhaps drafting the clause without those terms in it. And just kind of doing a little bit of language gymnastics where, we are saying that the employee, will be entitled to ESA minimums without this added language of, and we can terminate you at any time, and it's our decision, and so essentially, efforts. I know a lot of folks are making efforts to just kind of simplify uh,
Mhm.
these clauses a little bit more in order to try to get around this. So the refrain has been less is more these days as we are in this gray area. A simpler clause is probably better, but again, this is just my general observations. I would have to look at your specific contract, for example, to provide legal advice on that specific language. But I'm just telling you kind of the general approach that some folks have taken.
Thank you.
Okay. All right, so we're almost at the end here. I think we're going to be able to wrap up in a few minutes. Okay, and I'm sorry, I can't see everybody. Was there another hand raised? I didn't want to skip over anyone. No? Okay. So in terms of just some practical risk management strategies, I mean, in terms of immediate strategies, we can look back to a few slides ago where I had that list of, some kind of immediate action items you can take to ensure compliance with the new rules that have come into force in last year and the beginning of this year. So these are more so strategies that are just generally recommended in terms of general ongoing basis. So, and all of these are just meant to situate your organization to be as proactive as possible rather than reactive. Because it's when we're proactive, there's much less chance of us having to, spend money we didn't budget on to tackle a legal fire than when we're being reactive. So, tracking legislative changes. I mean, you're already doing a good job of that by, being at webinars like these. So just kind of tracking, what requirements are. Maybe you decide to have a staff person where part of their role is to, track some of these changes. Um, Again, definitely the biggest risk management advice that I offer you today is you're doing an annual employment contract review with an employment lawyer, just to make sure, because there's just such constantly evolving jurisprudence in this area that it just makes sense to, do an annual review of your contract and, avoid, like I said, those real life situations where, there's an unexpected payout that needs to occur. And then you're going to want to also, in terms of risk management, try to do periodic reviews of your employment HR policies. I'll note that under the Occupational Health and Safety Act, the act does specifically require an annual review of your health and safety policies, including that you'd want to include in that your workplace harassment policy as well. So this is just a generally a good practice to make sure that your policies are up to date, are compliant, and that they are kind of meeting the needs of your actual workplace based on past uses of the policy, what has worked, what maybe needs to be tweaked. So it's an opportunity for that. And there may be certain policies that lend themselves. I mean, so we've got the occupational health and safety policies that you're mandatorily required to review every year, but there may be others that lend themselves to more frequent reviews as well. So perhaps AI policies that more and more organizations are implementing, given the rapid evolution of technology. That may be one that you want to review every now and then, or if you have an electronic monitoring policy, again, given technological changes, that might be one that needs to be reviewed. So yeah, you can use your discretion there, but generally a good practice to undertake those periodic reviews. And then lastly, I think what I see a lot of organizations kind of fail to do, but that can also be an important risk management strategy is, you've got these beautiful policies in paper, but the organization hasn't trained management or staff on those policies. And I would say that particularly when it comes to human rights related policies, putting in your organizational calendar, some kind of tickler system or something that reminds you to provide even a brief training to staff, whether it's yearly or every 2 years. on these policies. If your organization ends up being in the unfortunate situation of having to respond to a human rights complaint of any kind, about the duty to accommodate or maybe harassment or discrimination related. When it comes to limiting the employer's liability in human rights complaints, tribunals, arbitrators will often take into account, well, what actions has the employer taken to try and mitigate this situation? And so the fact that you could point to training that you've done could help minimize liability in some of those human rights cases as well. So there is a risk management value to that. Okay. And so that, I believe, brings us to the end. And I'm so proud that I think I stuck to the 1 hour roughly, and haven't intruded on your lunch breaks too much. But with that being said, I'm happy if there's any other questions that anybody has. Feel free. I don't know if there's another one in the chat, Sam, or if anybody wants to raise their hand, feel free.
Nothing that I'm seeing in the chat quite yet.
Okay. Well, if other questions do pop up in your mind as you're thinking about everything you've learned today, you can feel free to contact me. I'm always happy to connect, especially with all of you lovely folks in this space. So, thanks you so much, Sam and Volunteer Ottawa, for having invited me, and thanks so much, everyone, for taking part of your lunch break to join us.
Thank you, Sasha.
Thanks, Clarissa.